Hello, I'm Sarah McCoubrey from the Ontario Justice Education Network, or OJEN, and this is a short video about the concepts of legal reasoning and how they integrate into the high school law class. Legal reasoning is a term that can be used to describe the whole set of communication and analysis skills that students use, that lawyers use, when applying facts to a new situation, when assessing the merits of a case, or when deciding if the issue that they're looking at is one that is a new or emerging area of law, or one that's already been resolved. Legal reasoning includes a number of skills that are familiar to everybody, but combined together represent the skills of a legal advocate. This is not an exhaustive list, but those legal reasoning skills include being open-minded, looking for both sides of an issue, considering alternative perspectives, identifying bias, evaluating sources, learning to distinguish between different kinds of evidence, applying precedent in a different way, arguing a particular viewpoint, imagining the arguments that will be presented opposite those viewpoints, considering how the argument that's put forward is going to affect other people. All of those aspects of legal reasoning, as you can see, are common sense, are available to everybody, are relevant in all different areas of our life. However, they're put together in a bit of a unique way in the job of a legal advocate. I see a great opportunity here in the way that you approach the education of students to build these skills of legal reasoning to help young people approach all of the issues in their life with reasonableness. Reasonable is a term that's used all the way through aspects of law. You'll hear it in reasonable doubt, reasonable search and seizures, the reasonable person test. This idea of reasonableness is used at law to assess the appropriate kind of behavior. Whether it's the behavior of a police officer, of an individual litigant, of a jury, it's still the term that's used to describe whether or not somebody is following or complying with our legal expectations and traditions. What does reasonableness mean? Is it anything different than being reasonable? Not really. However, what is different is how deciding for yourself how you're going to compare, how you're going to assess reasonableness. Is the measure of reasonableness what a reasonable police officer would do, or is the measure of reasonableness what a reasonable citizen would expect a police officer to do? When we decide if somebody should be held responsible for a car accident after a party, is it the reasonable party thrower, the person who's the host, that we look at, or is it a reasonable commercial venue? We use different kinds of comparators because the expectations we have on society are a little bit different in each case. So how do you as a citizen, how do your students as citizens decide if they're being reasonable, and what can they do by becoming more reasonable? When I talk to students, I always say this is the great secret of law school, and you can save yourself lots of tuition. If you learn how to be reasonable when you're 17, this is a strategy to get the things you want. I know that sounds like a really self-interested way to present it, but part of being reasonable is actually considering the impact it'll have on other people and modifying your expectations or your request to take into account those other perspectives, those other legitimate rights holders or interests. And in fact, what you want changes when you make sure that it's a reasonable request. Whether or not you want an extension on your homework assignment can be presented unreasonably or reasonably. And in fact, frequently students, in saying that they want something, when they're asked to present it reasonably, quickly say, okay, fine, I understand why you didn't grant that request. They can identify for themselves the way that it's unreasonable. So that's the aspect of reasonableness that might help you out in your classroom. It's also the aspect that has that young person become an adult who has reasonable expectations within society about the way people will treat them and the way they'll interact. And they'll get those reasonable expectations because they'll know how to apply the skills of legal reasoning to issues in their own life as well as to questions of law. Part of being reasonable is actually learning something about the area that you're talking about or that you're wading into, So learning how to educate yourself, to find accurate information, to tell the difference between a very opinionated source that may state what's wrong with the law compared to one that simply states where the law is at and what the rights are. How do you tell the difference between reliable online information? How do you tell if the online information applies in your jurisdiction or in your province? All of these skills of legal reasoning that, taken alone, don't look any different from basic research skills or life skills, combined together to help a young person be able to advocate for themselves, to advocate for other people, and to understand their place within the justice system as a component of our democracy. OJEN has been working over the last few years with the Ministry of Education on the new curriculum expectations that will be coming out for Canada and World Studies, and particularly for the law classes. And legal reasoning, as the knowledge and communication skills, will be integrated throughout the law courses, and that will shift the focus away from simply doing research or writing a paper on a legal issue to actually doing activities in the classroom that apply the skills of legal reasoning and help people to actually be an advocate. For example, doing a mock hearing, a mock trial of some sort, requires somebody to learn about an area of the law, apply cases, decide for themselves what the best arguments will be, but it also requires them to anticipate or imagine all of the arguments against theirs, consider which of those may change the approach they're going to take, which are more valid or supported, substantiated than their arguments. That might change the focus that is put forward. It also is going to require them to synthesize all of that into an oral argument. Trials are oral arguments. They aren't written arguments. If they're doing an appeal, it might require them to synthesize them into written arguments, which do happen in that context. So it's actually taking the structures of the justice system and integrating that with the skill sets that you as a teacher have always had in mind in various courses, but now are coming together with this lens of legal advocacy. Certainly when we think of an advocate, most people think first of a lawyer. And of course that is the job of lawyers. However, people are advocates for themselves, for their family, for their coworkers, for their neighbors, for the person sitting next to them on public transit all the time. And that skill of being able to be an advocate is invaluable to both managing conflict in their own life and standing up for the rights of other people. When we talk about being an advocate, part of the job of being an advocate, or the skill involved in being an advocate, is being able to identify the legal issue and separate it from the emotion or the unrelated details of the situation. And that's often the most difficult part for young people. I'm sure you've had the experience of getting a long story that leads up to a question that actually has nothing to do with the story. But for that person, these events are all intertwined together. It's a skill to be able to look at a whole situation and figure out which part of that relates to the question at hand, how to not focus on the rest of it that is in fact confusing or gets in the way, and then to communicate that one aspect and the facts relevant to that one aspect in order to put forward an argument about what somebody wants to have happen or what they think should happen in a given situation. So this skill development is an important aspect of developing the skills of an advocate. At OJEN, we rely on some research that has looked at how to develop legal capability. Capability would be the ability to deal with legal issues as they come up in your life. And that research identifies 3 components to legal capability. Knowledge. The knowledge part is easy. We've got websites all over the place that outline your legal rights, how the courts work, where the forms are that you need to fill out, all kinds of information in brochures, from lawyers directly, from paralegals, or online. So knowledge is the first component. The second component is skills. And I just mentioned one of the skills, the ability to communicate the issue and to identify for yourself the difference between the circumstances of the situation and the actual question that you're approaching. There are other skills, like the ability or the skill to present that information in a concrete way, to ask for help, to go to appropriate sources and get that assistance. And then the third component is attitudes. And attitudes are really interesting, especially when we look at young people. It's the attitude or the belief that you are worth a fair resolution, that a system can be trusted, that the justice system doesn't require a bribe, it isn't racially biased. Those are attitudes about the justice system. And this research about legal capability concludes that you need all three of those in order to be able to do anything about the legal issues you've had. Historically, I would say the justice system has done a great job on the first one, knowledge. There are all kinds of free online resources. There are links on the OJEN website to many of those sources in different subject areas in different provinces about basic legal rights. What the justice system hasn't done as much of is help people build the skills or shift the attitudes in order to feel comfortable going to a lawyer, asking for help, knowing that they are going to get a fair treatment. And this is where OJEN's model and what happens in classrooms is a huge component of it. Whether or not a young person at the end of the year of your Law 11 or Law 12 class has memorized every aspect of the charter or the various defenses to criminal charges is not that important in terms of whether or not they will manage legal issues in their life appropriately. However, if they have developed the attitudes that the justice system is a place where you can get fair resolution of your legal issues, and the skills that help them know where to look online, not be afraid to call a lawyer, understand how to manage that managing their legal issue early might be cheaper and more efficient than doing it later, those skills and attitudes are going to stick with them throughout their life. And they may not have a dispute for 15 years, and when they do, it might be a real estate dispute and you didn't cover it in your law class, but they're still going to understand how lawyers fit into the equation of helping them to resolve that issue, how to get that help, what questions to bring forward. They won't necessarily be as intimidated. They will, if they come from a different country or have immigrated to Canada, will understand the difference between our legal system and others. So that's where the skill and attitude development that you're doing through that legal reasoning and the development of reasonableness, in my opinion, is the more important part to come out of a high school law class than the substantive knowledge. Substantive knowledge will change. By the time they need to deal with a small business issue, the legislation might have changed. At that point, they'll need to understand how to get good information, how to ask for help, and how to update their understanding of it, rather than how to rattle off a checklist of the components that might have been in place when they were in high school. So legal reasoning is a tool that can help you. It's a tool that helps students, and it builds that kind of skill and attitudinal change that's necessary for young people to deal with legal disputes throughout the rest of their life. Frankly, it's also the more interesting part of teaching law. It encourages students to have dynamic discussions and debates, to form their own opinions, to defend their own opinions. This is where you have a lot of freedom as a law teacher to engage students on the issues that they care about. Have them argue themselves, advocate for other people, switch sides and have to advocate against their own opinion, participate in mock hearings, do a mock appeal, argue sentencing matters. All of these experiential learning opportunities that are more fun for the student, more engaging for you, are also building those more important lasting skills. So I caution you to avoid the checklist approach to substantive law and to not be too afraid of whether or not you've got the law right, so long as you're building that capacity for students to engage in legal issues throughout their life, to do research, to ask for help, to understand how the system works. You will have done more to build their legal capability than you will if you focused on the substantive law, and hopefully it'll have been more enjoyable and less stressful along the way.